So here's the thing. I went to go see Superman.
Okay.
Let me just tell you what my biggest problem is.
Okay.
You put it right here. You said this is where it was, right? It's up here. That movie was awesome.
Sure, I didn't oversell.
Oh, no, you couldn't oversell it. And you know what? I will tell you, this is the first Superman that I've ever watched where I can see why. Okay, somebody would say, well, he sort of looks like Superman, but he's not. So I'm telling you right now.
In my opinion, that sucked.
So the court is calling.
Up in the sky, it's a bird. It's a plane. No, it's purse check.
563 State versus Ronald Lamar Allen. Can I have parties announced?
Megan Galley versus State.
Charles Butcher for the accused.
And are you Ronald Lamar Allen?
I am.
Right, so before we take up any settings or discovery issues, counsel, you filed a motion requesting a reduction of bond.
That's correct, Judge.
All right, and what is the bond currently set at?
That bond is currently set at $100,000.
And State, are you in agreement to reduction?
No, Your Honor.
All right. And State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, it is your motion. Do you have any witnesses?
Yes, Judge. I have Ms. Evelyn Allen is here. She's the mother of the accused.
All right, Miss Allen, if you'll come forward, please, and sir, if you'll stand near that computer. Yes. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need to make sure you keep your voice up because one, I need to hear you, and also the court reporter needs to hear you. Cindy, do you need her to wear the little microphone or no?
No, she's in front of the mic.
All right, if you'll state your name for the record, please.
Evelyn Allen.
All right, that's the right tone
Oh,
for me
good.
here. Thank you. All right, defense, you may proceed.
Miss Allen, are you the mother of Ronald Lamar Allen?
Yes, I am.
And how long has Ronald lived in Bexar County?
Over 8 years for sure.
And for the court, would you describe your relationship with your son?
We're very close. He lives with me, so he does help out around the house quite a bit.
Just look at her body language. Her arms crossed, eyes fixed, completely unreadable. This is where courtroom psychology takes over. Every small gesture speaks louder than words. She's not just listening, she's calculating. And that silence, it's not weakness, it's control. Watch what happens next. It's about to shift.
Yard work, grocery shopping. We have a close relationship as far as sharing.
Now, Miss Allen, are you aware of any past instances where Ronald has failed to appear for the court?
No, not at all.
And under the circumstances of his custody battle, he's had to be in court a lot of times. Is that right?
Oh, yes.
And how long has his custody case been going on with the ex-wife or his ex-girlfriend?
Well, the trial is 8, so I would say close to 8 years old.
Now, are you aware of any past instances where Ronald has attempted to flee the jurisdiction or avoid any court proceedings?
No.
And if Ronald were released on a reduced bond, would he have a place to stay?
Yes.
And would you be willing to supervise or help monitor him if it was required by Judge Boyd?
Yes.
And can you describe any of Ronald's involvement in his family or community prior to this arrest?
Ronnie is very light. In fact, one of the neighbors is here with us today that he's helped out. She's had health issues and he would bring her hot meals, take care of her yard. We in an elderly neighborhood. He's helped the elderly clean their gutter if they need to move heavy flower pots, whatever. He was well liked by all the neighbors in the neighborhood.
Now, Miss Allen, Have you ever made any efforts to post Ronald's bond?
I've made several attempts. I've called about 5 bondsmen, and each one had different regular stipulations. Once was like I needed 4 signatures, co-signers, they called them, that had to have employment and live in Bear County, that would be responsible if in the event he would skip out for the $100,000. Plus a collateral of putting my home for collateral. And then another one required, I think, co-signers other than me, two co-signers, but other than myself or my husband at the time, be at peace.
Now,
And and collateral, whether it be like my home or with 100,000, and I think the bonds, they started at 10,000, but said it could be up to the discretion of the manager of the bonds company. It could be more, but not less.
now, Ms. Allen, do you believe a lower bond would allow your family to safely and responsibly secure the release of Mr. Allen, of your son?
It would be affordable, yes.
And what financial resources have you exhausted trying to help Ronald?
I'm embarrassed to say, but I've limited out all my credit cards and all my credit. Thank you. And
Here comes the moment that changes the game. The attorney doesn't raise his voice, doesn't flinch, he just drops the facts, like bricks.com, precise and brutal. And did you notice the smirk right there? That's not arrogance, that's a lawyer who knows the trap just closed shut.
now that my husband's gone, that income is ceased, so it's very stressful and trying to find funds to.
Can you tell the court about your late husband, Ronald Wayne Allen?
Glad to. We were married in April for 52 years. We went to high school together. We had our class reunion, 55-year class reunion in September, which I'm glad we got to share that. And our anniversary, we're from Louisiana, so we got to share crawfish. And I'd like to say that for his final days, he enjoyed that, but it was a shock that he passed.
When did your husband pass away, Miss Allen?
June 13th.
And this was while your son was in the jail?
Yes.
And how did Ronald respond to the loss of his father while he was in jail?
Very stressful, very anxious. He just wanted to give me a hug and support, be with the family. At first, I don't think he realized that he had passed because I couldn't tell him. And I don't think reality set in now. He's very, it's stressful. He says that he thinks of him a lot, trying to sleep, and that just needs to give me a big hug.
Miss Allen, has Ronald been able to attend any funeral services or grieve properly regarding your husband?
Your Honor, because I have 2 boys and myself. We're waiting for Ronnie to be able to attend the services before we can schedule them. We're from Louisiana, so our main service would be in Louisiana, Lafayette, Louisiana.
Miss Allen, from what you've observed, does Ronald struggle with any mental health concerns?
Very anxious, very stressful. The stress being in prison, jail, how they call it.
And has he ever had any mental health conditions? Has he ever suffered from schizophrenia, bipolar disorder, or anything like that?
No.
And do you believe that Ronald would benefit from counseling or evaluation if released?
Oh, absolutely. He and I both to be able to grieve, learn how to grieve together and get beyond this, because we need closure, and we need to share that bond It's very hard for me. All alone at the house.
Now, Miss Allen, regarding these underlying charges, have you ever seen your son engage in anything violent or have any violent offenses, or has he ever lashed out at you in any way?
No. No.
And regarding these underlying charges, maybe you can tell the court a little bit about what these charges have meant to you substantially.
Trying to understand the charges. At first I said, this doesn't sound like my son. But again, he can get excited, he can get anxious. He was struggling with the custody. and the process that was going on. And he can get excited, and we're from Louisiana, so he may raise his voice, but as far as he wouldn't even hurt himself. I mean, he's very, very controlled person. He's very low key. I've never seen him ever say anything to harm anyone. And I'm going to bring in the custody was for his child that he loves very much. He's a very good father.
Judge.
Any questions?
Miss Allen, just briefly, I have a couple of questions for
I'm
you.
sorry.
I said, just briefly, I have a couple of questions for you, okay?
Okay.
You stated that your son moved to Bear County about 8 years ago.
Yes. I mean, he's been in Bear County as long as his child's been born.
Okay, do you know where he was living before that?
I can't, when they were married, they lived in, Wimberley?
Okay, Wimberley, Texas?
Yes.
And then, before that, did he live in Louisiana with you and your husband?
I've been in Texas for 52 years.
Okay, so at any point, did your son live in Louisiana or no?
He may have stayed there to help a family member. His grandmother had eye surgery at one point, and his uncle lived,
Do you have like a 401k or any retirement from your job?
Now freeze this frame. You can almost hear the courtroom breathe. The witness hesitates not because they forgot, but because they realize the truth isn't on their side anymore. This kind of pause tells you everything. No objection needed because the damage is already done. That's how subtle a collapse begins.
I have a retirement, but I don't survive on it. I
Okay.
survive on Social Security.
So about how much income do you get monthly?
I don't remember, but I think it's like, $1,500 and $1,600 a month.
And before your son's arrest, was he employed? Okay, what was he doing for work?
He was like, what I understand, a courier, like delivery.
Okay. Was he employed with like a company or self-employed? Do you know?
I think he mentioned, I didn't get too much into his business, but like a self-contract or contract.
Okay. And do you know what his like hourly rate was or monthly rate?
No, I didn't get into that.
Okay. Do you know if he has any savings accounts?
I can't answer. I don't know.
Okay. You guys haven't discussed that in your efforts to make his bond? If he has money saved up to assist you?
When we talk on the phone in the prison, we try to keep everything generic for the privacy,
Okay.
and not get into financials to keep it private. So if fine.
Okay. But you would agree with me if he had some type of money or savings that would help you try to make his bond, right? That would assist you in your efforts. And then as far as your home, you said you've lived here for 52 years. So do you own your home currently or are you renting? You own it?
Mm-hmm.
Okay. And do you have a vehicle that you own?
Yes.
Okay. And what about your son? Did he have a vehicle that he owns?
No.
No. And what about a home? Did he have a home that he owned prior to this?
No.
Are you aware of any of your son's prior arrests?
When he had his divorce.
Okay. Would that be around 2015? Have you heard that he was arrested for assault, family, house, impeding breath or circulation?
Is that in Jordan? I'm sorry.
Were you aware that in 2015 he was arrested for a family violence assault, including strangulation?
I was aware that he had a legal issue with his divorce, yes.
Okay. And then before that, in the year 2000, were you aware that he was arrested for possession of marijuana between 5 pounds and 8 pounds?
I believe that I had not.
You did? Okay. And then were you aware that in the year 2016 or 2015 that he was arrested for unlawful restraint?
In
2015.
I don't recall.
Okay. And were you aware that in 2016 he was arrested for assault, bodily injury against a family member?
In what year?
2016.
No.
We pass the witness, Your Honor.
Any further questions?
Yes, I'll take short redirect. So, Ms. Allen, you are aware that your son has had some violent instances, allegations. Where were these allegations regarding the family violence assault coming from? Like, who do you think is actually made these allegations against your son, Ronald?
The one that I said I was aware of would be the ex-wife.
And have any of these allegations and any of these charges in the past, have they resulted in Ronald going to jail or having a conviction?
Not that I'm aware of, no.
And put under your supervision?
Yeah.
All I have, Your Honor, regarding this witness.
All right, any further questions?
No, Judge.
Any objections to the court asking a question?
No, Judge.
All right. So in your home, are there any weapons? No guns?
No, ma'am.
And if your son were to make bond, he would be staying with you?
Yes, ma'am.
And is that in Bexar County?
Yes, ma'am.
All right. Any other questions from either side?
No, Judge.
Any
No,
other
Judge.
questions with this witness? I'm sorry for your loss. It is so rare to see people who are high school sweethearts get married and that it lasts for that length of time. All right. Thank you so much for coming in.
Thank you very much.
Counsel. All right. The court will hear argument.
Judge, in addition to all of this, I do have a copy of Ronald's father, Ronald Wayne Allen's death certificate, so that we know that this is an honest
Oh, no.
regarding this man. He was an Army veteran. And
all right. And I reviewed the document. And counsel, you're an officer of the court.
all right. Thank you, Judge. Regarding this matter, Your Honor, we're here today on this motion to reduce bond filed on behalf of Ronald Allen. Mr. Allen is currently sitting in the custody under conditions that neither reflect his flight risk nor serve the purpose of public safety. We think that this incarceration, in fact, functions as an instrument of oppression prohibited under the Texas laws and the United States Constitution. Under the Article 17.15 of the Code of Criminal Procedure, the court must consider the following factors. The bond must be sufficiently high to ensure appearance. It may not be used as an instrument of oppression. The nature and circumstances of the offense must be considered. The accused's ability to make bail must be regarded, and the future safety of the community and any alleged victim must be weighed. Further, Article 1.07 guarantees that bail is a right, and Article 17.09 permits this court to modify bail at any time prior to his conviction. The Eighth Amendment of the U.S. Constitution prohibits excessive bail, and the 14th Amendment's due process clause requires this court to avoid pretrial detention solely on the basis of poverty. The application to this case is that there's been no physical confrontation.
Pay attention here. This is where the judge leans forward, only slightly but enough to signal, "I'm listening very closely." And when a judge does that, it means the next sentence could decide the case. You'll miss it if you blink, but this is the pulse of real courtroom tension.
And no victim impact regarding this case. The underlying facts of the case would show that Mr. Allen was in a private conference with his custody lawyer at the time of the alleged offense. We want the court to understand that this was an emotionally charged conversation because of a long custody and visitation battle with his ex-wife, and his family attorney had only been retained for several weeks. The statement that he made that gave rise to the terroristic threat charge was made outside the presence of any alleged victim, and there is no indication that Mr. Allen took action to carry out any of his threat. The case was documented by the San Antonio Police Department and the Fusion Center, but it resulted only in an information report, not an arrest at the time. No firearm, no plan, no attempt, just words spoken in the distress amid his ongoing family court litigation and the emotional duress. Notably, the complainant himself, the attorney that he had, called the SAPD out of an abundance of caution, but he was not in fear. The compelling personal circumstances on this case are, there's been no evidence that Mr. Allen poses a threat to any person if released. He does maintain there is a civil protective order between him and his prior lawyer because he's the one that made the report and the outcry regarding the terroristic threat. But he would abide by that protective order substantially. There is, however, evidence that the current bond amount is far beyond his means and his family's means, and we believe that it's unnecessary to secure his return to court. We are requesting at this time that the court consider reducing Mr. Allen's bond to a reasonable amount or releasing him on appropriate pretrial conditions, which may include GPS monitoring, counseling, or any mental health evaluation if the court deems such conditions necessary. We believe that this would align with the Code of Criminal Procedure, Article 17.15, as well as the constitutional safeguards designed to protect the rights of the accused while preserving public safety. From where I'm sitting, I recently became his second criminal defense lawyer, and it is a difficulty for me to prepare for a complicated, what's likely a complicated trial regarding this case. I've filed motions to suppress and a motion to dismiss this charge, but I'm not here on that today. I'd like to get my client released under a reasonable bond so that I can prepare and have him prepared for those hearings outside of the jail.
All right, State.
Judge, we believe that the bond has been set in a sufficient amount regarding public safety. Regarding the testimony that you heard from today, it sounds like, well, the mother does have limited needs. She does have several items of collateral available to her, and there's also this untapped resource in the defendant's own personal belongings, financial resources, and bank accounts that they've neglected to speak about for privacy reasons, as testified to by her. And then regarding just the flight risk, I mean, he does have ties to locally Texas and Louisiana, so we would ask that you keep the bond amount at $100,000.
Judge, I guess if I may, with respect to the family resources, they are. She doesn't have a lot of access to a lot of the funds that might be available in their normal circumstances if Ronald's father was alive. Just weeks after Ronald was incarcerated or jailed, This man died. And so we believe, and Ms. Allen has advised me, that a number of those resources and properties are going to be tied up in probate in the coming weeks.
Well, let me just explain something. I don't believe that someone should be required to put their home up for collateral to make somebody else's bond. So I'll just lay that there. That is gambling to put your home up.
Yes.
Because the bondsman will take your mother's home if you fail to appear.
Mm-hmm.
So this is the court's issue. So I've read, defense, I've read your motion. And in your motion, you put that Judge Hortek found that your client wasn't a threat to his son or the community at large, and that there will be a protective order regarding his ex-wife.
Yes, there is, Judge.
And that he will be allowed to proceed with his visitation rights. So I don't understand, on the civil side, they said he was going to have his visitation rights. It's going to be supervised, and they wanted a psychological evaluation. I don't understand how we go from that to now he's before me on a charge of terroristic threat. And Mr. Allen, I want you to know I don't take any of this as true because I haven't heard any evidence on the facts. The reason why I bring that up is because, as you stated, counsel, part of the things I consider in a bond reduction is safety of the community. So in this case, safety of the community would be based upon the indictment, the community at large, and also the protective order that your ex-wife has, her safety as an individual, but then the community at large, based upon the exhibits that the state had me read, which was part of the police reports. So that's the court's concern.
Well, Judge,
And has he done a psychological evaluation? Has that been done, or was that completed?
no, Judge. The order coming from the civil case, from my understanding, I'm not a civil lawyer, but my understanding is that that final order in that Satzer modification that was filed by the ex-wife and was litigated while he was in jail through Judge Hortek, that is pending as far as the order being signed.
Okay.
There are judge's notes that indicate what I mentioned in my motion, that the protective order against the son was denied. There is, I think there's other ways to secure the community other than a $100,000 bond. I think a GPS or any kind of tracking would be able to secure compliance. And if there's a bond condition that prohibits his contact with either the complaining witness in the underlying terroristic threat case, or who I believe did get his own protective order, and then also a protective order, or rather a bond condition that prohibits his contact with the ex-wife, and ask him to remain in the jurisdiction. I think that can mitigate some of the risks of him not coming to court.
All right. And state?
I would just reiterate my prior arguments and then the testimony regarding his prior arrest.
All right, this is what the court is going to do. With regards to your other motions that you filed, the motion to dismiss and the motion to suppress, we'll set those for hearings and y'all confer. And I would like those hearings set as quickly as possible because that may end up addressing whatever issues are here. But Mr. Allen, I'm going to deny the motion to reduce bond. I'm going to order that there be partial GPS for employment only. GPS fees will be waived. and there be a referral to Center for Healthcare Services. So if y'all would confer with.
This closing moment doesn't just wrap up a case, it exposes every thread that unraveled along the way. The jury's faces say it all, and if this moment gave you chills, you're not alone. Stick around, we break down courtroom power plays like this every week. Like, comment, and subscribe.